Hello, everyone. Welcome to the Legal Matters podcast. My name is Christoforos Christofi. Today is Tuesday. It's the 23rd of March. The time in Cyprus is 6 o'clock, and we have a very hot topic today. I have the pleasure of hosting here a discussion on international arbitration with very distinguished guests, beginning from George Lambrou, who is in the United Kingdom, in London. George, welcome.
Hello.
Dr. Anna Plevri. Anna, good evening and welcome again to the podcast.
Hello, everyone, and thank you for being here
And
today.
for the first time, my colleague, Mr. Agis Georgiadis. Agi, welcome too.
Thank you and good evening to all.
So I welcome you all. It's a dusty day today in Cyprus. How is the weather in London, George?
Well, actually, at the moment, it's what you would expect. Yeah.
Okay. Well, in the last couple of days here, it has been awful. We have a lot of dust. They say it comes from the desert, and you cannot breathe, and it's really very bad, very bad. Okay, so let me make an introduction first. I will say very, very few words about my guests today. I will link the CVs of all the three of them, beginning with George. George is a solicitor, advocate practicing in England and Wales. He has extensive English High Court experience and, of course, international arbitration experience with the ICC, the LCIA, the LMAA, and ICSID. He sits as an arbitrator, and in his free time, George is the co-director of training for the European branch of the Chartered Institutes of Arbitrators, and he speaks fluent Russian and Greek. Where did Russian come about?
Russian, it's an interesting story. I lived there for 6 years. I was sent there on behalf of the U.S. government, and so therefore I can't disclose this in public, what I was doing.
Okay.
No, it's not a secret. But we were helping to develop investment and trade in Russia. This was in the 90s. And as a result, that's where I learned the language.
Okay. Very interesting. So Anna is an attorney at law. She comes from Crete. She's an islander like us. She's a member of the Cyprus Bar Association, of the Bar Association of Thessaloniki. She's a certified mediator on civil, commercial, family workplace disputes and ODR, a certified mediators trainer, an arbitrator, and a lot of other things that I will not repeat here. She's assistant professor at the Department of Law in the University of Nicosia, and she lectures private law and ADR at the University of Nicosia. And now I need 2 hours to spell out all your qualifications.
I think this panel is a dispute resolution panel. So we're all doctors, actually, because it's dispute resolution.
Okay. And my friend Agis Georgiadis, he's a barrister. He's an accredited mediator and a fellow of the Chartered Institute of Arbitrators. And Agis is the first Cypriot member of the London Court of International Arbitration. And we are very proud about this accomplishment, Agis. And he practices law at the Cypriot law firm of Christos Georgiadis and Associates. Okay, so a small introduction. I will link the CVs. So we said today that we are going to make a discussion about international arbitration. George, this is a topic that has become very hot in Cyprus in the last few months in view of the lockdown and in view of the problems that we have in the administration of justice in Cyprus, the delays, the problems with execution of judgments and so forth. So we have been discussing in this podcast many times alternative dispute resolutions. I have had other guests as well in the past. So we thought that it's a good idea to go a step further and explain to our audience, which are primarily lawyers and accountants and other professionals, how to become an arbitrator. We thought of inviting you as a principal guest to explain the process and the procedure, and Agis and Anna will contribute along the way. And I would like to start. Actually, all this was Anna's idea, so I wasn't the one that thought, but actually it's a very good idea. So let's start first of all by giving a definition of arbitration and international arbitration. Can you tell us what it is, how it came about, and any experience you had with Greece and Cyprus the last years?
Sure. Well, first of all, thank you, Christoforo, for inviting me. This is a fantastic program, and I've heard so many things, and I've watched a lot of the other episodes, and I have to say, it really is. It's one of the good things, I think, which has emerged out of coronavirus lockdowns, is that we've explored other ways to communicate, and it actually has created these types of forums like yours, and I'm just so grateful to you for inviting me. So thank you very much.
It's my pleasure and our honor, George.
Well, thank you. Well, arbitration. Let's talk about what is arbitration, and many people describe it as you did, as an alternative dispute resolution mechanism. But I sometimes wonder about really whether it is the alternative or maybe it's the primary. Historically has perhaps been the primary, or one of the primary means that business people actually resolve their disputes. If you look back, there's a brilliant book which I brought here to show. It's Ancient Greek Arbitration, by Derek Robick, and this is, it's not a small book. Okay, so there's actually quite a lot of arbitration, which was the most common form of dispute resolution for merchants in ancient Greece and of course in Cyprus. So from the places where we're from, and not just the places where we're from, but if you look at also in China or all over Europe, people didn't really go to state court. Don't forget also they didn't actually have nation states. It was city states, and of course there was the dicasterio. But the dicasterio was not the place where people really wanted to go. Business people did not want to go to resolve their disputes there. So and there's lots of good reasons for that. So a typical arbitration clause that we would find in ancient times would be that, in the event of a dispute, the matter would be referred to, let's say, 3 merchants of the port. So a relatively simple arbitration clause, but one which was clearly a choice not to go to the courts, but to have the dispute resolved privately by fellow merchants. And there's lots of good reasons for that. And those reasons exist today. So really when we're talking about international arbitration, we're talking about disputes which are resolved privately between the parties and by a neutral third-party tribunal, or which might be either 1, 2 even sometimes, or 3 arbitrators. So it's nothing new. It's nothing alternative. It fell out of fashion, perhaps, with the rise of nation states and the centralization of governments, but that's actually a relatively recent phenomenon. So my view historically is that actually it's returning back to its preeminent place among merchants as the means to resolve commercial disputes.
So you are saying that the origins of this had to do with merchandise disputes, and it originated from there, right?
Absolutely. I mean, as far back as we can tell, we have arbitration clauses. We actually even have arbitration being conducted among the Greek gods in mythology.
Yeah.
So it's a fundamental means of resolving disputes, which has been around since the beginning of the Western civilization.
Actually, we have a colleague here, Nikos Papaevstathiou. I don't know if you know Nikos. He's the managing partner in Dassos Papadopoulos law firm, and he published a book lately, and we had a podcast about this a few weeks ago. It's the first book on commercial arbitration, international and the Cypriot practice, and he refers to this and about the roots of arbitration, and he refers to the example of the Greek gods, that it is the first one of the first recorded cases of that we had arbitration, and everybody went before Zeus to obtain justice and submit their case. So Anna, can you contribute here and tell us why are Cypriot lawyers not accustomed with the arbitration and international arbitration? And for most of the practicing lawyers, it looks something like it's not something common. It's not something that everybody knows.
Thank you, Christopher. And I would like also to say that I'm very pleased and honored for having George with us today. George is an expert, a really expert in ADR and arbitration, and he also is an insider. So it's the one to ask questions indeed today. So I totally agree with George. I think arbitration started among the merchants and those who wanted to find solutions when it comes to problems of trade. And yes, we can claim, the Greeks, we can claim again that it's an institution coming from Greece, from our country. Also, Aristoteles refers to arbitration in a very explicit way. Excuse me, I will say it in Greek. It says in a certain point, Aristoteles, ο μεν δικαστής, ο μεν διαιτητής το επιοικές ορά, ο δε δικαστής το νόμο. Και τούτου ένεκα επιοικές ισχύει, όπως διαιτητής ευρέθη, όπως το επιοικές ισχύει. Which means that the arbitrator needs to apply the law, but also by bringing a balance to the dispute. It is about applying law also, and this is something that people should know, that it's a kind of, it's not a kind, it's a trial, it's a court, it's an arbitral tribunal, let's say in a more correct way. So there is a litigation there. When it comes to Cyprus, I don't actually agree that the Cypriot lawyers, they are not involved in arbitration. The thing is that not many of them are involved. So there are certain people that they are involved in the arbitration practice. I do know that Agis is one of them, and some others. But what is missing is to have the arbitration as one of the dispute resolution methods, as a tool in our services. So we need to expand actually the tools, the possible methods of dispute resolution by explaining to our clients that there is this path too. So there is another book, The Three Paths of Justice. Well, sometimes I'm not sure if to resolve a dispute, it's always a matter of justice. This is debatable. But I do think that in certain areas and in certain sectors, arbitration is a very fair solution, I would say, because you know from the beginning certain things, and you have taken certain decisions, and you can go among them. Okay. So it's actually a little bit weird that in a jurisdiction where delays are, you know how the system works.
Yes, it's very hard. Yeah.
That ADR methods in general are not so popular, but I think this is something that changed now. That's my view.
Okay. So let's go into specifics now, Agis. When we say international arbitration, for example, in our case, in the case of Cyprus, do we need to have an external party involved in order to qualify as international arbitration? I mean, when we say international, what do we mean exactly? It has to be foreign entities? How does it work?
Well, when the parties in a dispute come from different states, then that dispute can be characterized as an international dispute. Of course, it's not always that simple to know because there are some very complicated cases, for example, where companies move their seats from one country to another, or when one of the parties is a consortium. But if we take the simple case where we have two parties from different countries, then that would amount to an international dispute. And it is important to know, it's very important to make this distinction because of the application of the New York Convention. This convention, which is basically the convention which enables the recognition of arbitration awards in all member states, now counting more than 150, applies only to international arbitration.
Okay, so George, I'm coming back to you now. Of course, you are an expert. You have a lot of experience in this. Can you tell us what are the benefits of arbitration and international arbitration in general, and why would someone do that instead of going to a traditional courthouse?
Okay, well, thank you. And again, let's look at it as the primary, because actually the reality is that today when you have international contracts, at least the ones that I come across, it's the norm to see arbitration. It would be unusual for me to have, for example, a Spanish company and a Chinese company agree to the Spanish courts or to the Chinese courts to resolve their disputes. They're going to, more likely than not, I would expect to see arbitration. Or international arbitration. So what are the benefits? Well, first benefit is that it's a neutral forum. So as I alluded to just now, neither of those parties would feel comfortable necessarily having their dispute litigated in the court of the other's country. The alternative might be to then seek to find a third country, where they could go to the courts of that third country. But I'll give you an example from my own practice. So if you were to choose, let's say, the English High Court and to resolve your disputes, and let's say you had a Cypriot company and you had a Russian company, and they've decided to have a neutral form English High Court. Well, the first thing that they're going to have to do before issuing the claim form, or after they issue the claim form, is to actually serve that claim form on the respondent in Russia. So in order to do that, it's not simply a matter of sending an email or even a matter of getting a Russian lawyer to stop by the offices of the Russian respondent. You actually there's quite a formalized process of serving just the service. And it's done through something called the Hague Convention on Service of Foreign Court Documents, and that is done essentially through diplomatic channels and then through the domestic court system. And to give you an idea of how that cumbersome that can be, I had a case recently where the amount of time it actually took the claimant to serve the respondent with the claim form was over 6 years.
You haven't had experience from Cyprus.
So that's before you've even gotten started. Okay, 6 years. Of course, everything needs to be translated into Russian by the official translators, and then the claim form expires every year. So then you need to apply for an extension of the claim form. But then that application also needs to be served. Okay, so it can be extremely costly and cumbersome, and that's simply to get the claim started. Let's not even talk about enforcement. Okay, so let's say that you've done that. There's no automatic means to enforce the English court judgment in Russia.
But it's the same with arbitration, isn't it? The decision of the arbitrator has to go. No.
You see, so this is there is no legal agreement between the UK and Russia for mutual recognition enforcement of court judgments.
Okay.
Whereas with arbitration, as Agis referred to earlier, you have the New York Convention, which is a convention which both Russia and the UK and most countries in the world have signed up to, which provides the legal framework for enforcement of that arbitration award. So if you had a London arbitration award, you could then go to the Russian courts and say that there's a legal framework by which the Russian courts are required to recognize the English award as if it was a Russian award. So it in some ways removes that international element from the enforcement mechanism, and you then actually have a legal framework. I'm not saying that it works perfectly all of the time, but at least you have a legal framework, which you don't necessarily have if you're talking about a high court. And that's just one small example of why arbitration is preferable in international contracts in most cases.
Yeah, usually people argue that the arbitration is very expensive, especially international arbitration and involving London and LCI and so forth. So what is your opinion on that? I mean, it's really expensive, isn't it?
Well, look, there's lots of different. Again, it's hard to generalize. I think that London, of course, has a reputation for being expensive, but I think many of the times it's really up to the parties to control those costs. Most of the costs, which people complain about arbitration, are actually incurred by the parties themselves. The tribunal costs are a very small fraction of the actual costs. So I think part of the reason that reputation has emerged is because it was arbitration, I think, the way it's been practiced in the last few years has been dominated by a number of large international law firms, many of which have American roots. But that's certainly not universal. That's not necessarily the case. And I think as we've seen the last 10 years, there's been a great emergence of what we call sort of boutique arbitration law firms, which have highly experienced, highly qualified practitioners who are able to run cases in international arbitration at really a fraction of the cost of some of the more of the big magic circle or the large firms, which I think have been traditionally dominated in that area. And as consumers, I think of arbitration have become more sophisticated, and I think that now they're looking very carefully at the costs, and I think that has a result of hopefully bringing down those costs.
Okay. Thank you about this. So,
say something. I mean, it also depends on how you quantify the benefits you get from referring to arbitration. Because let's say that you have an international dispute which is referred to the Cypriot court, and you ask for a claimant who is claiming 10 million euros. You go to the Cypriot court and you wait for 8 years for judgment. Once that is done, you wait for 1 year for a writ of movables to be executed. And it takes another 5 years before you can get any cash, cash if you get any. So that's 13 years. And it costs 80,000 euros according to the scales of the Supreme Court. And you compare that to going to an ICC or LCI arbitration, which is held in a year and a half or 2 years. It costs maybe 300,000 euros. But in 2 years, you have an award which you can enforce in 150 states, depending on where the assets are, if any. So I think that this example shows that it is quite relevant how you pay and what you get out of it.
Did you have any practical experience of enforcing arbitration judgments in Cyprus, international arbitration judgments?
Yes, of course, but the issue, look, our courts are quite good at applying what is termed the pro-arbitration bias. Our courts are in favor of enforcing international arbitration awards. Mm-hmm. The problem is not there. The problem is once you get the award recognized, mm-hmm. that the enforcement measures that can be taken in Cyprus are quite limited and not very effective. So unless there is money in the bank and you freeze the accounts, or there is immovable property which you can seize in some manner, it is very, very difficult to enforce a judgment or an award. But that is that's the same for all types of proceedings, yes. Unfortunately.
So, Anna, this is what I was asking George before about the enforcement of an arbitration judgment at the national level. And what is your comment about the enforcement proceedings here in Cyprus from your experience? I mean, we hit a wall most of the times, don't we?
Yes, that's true.
And does this negate the whole arbitration advantage, would you say?
First of all, I would say, to sum up, that the benefits of arbitration, of international arbitration, actually, is again from the view in terms of time, cost, procedure, enforcement, and recognition. Mm-hmm. So yes, I agree that it depends. It is expensive if the parties do not control the expenses. It is the way they design the clause and the way they choose actually ad hoc arbitration or institutional arbitration, and which institution. So it needs a certain research before you decide what path are you going to follow. The thing is that international arbitration exists, to my view, because the New York Convention exists. So it's not the same with the decisions of the courts. We don't have an international convention to enforce decision of the court to other states. So regarding the enforcement system in Cyprus, yes, we do hit wall, because as I said, we don't have enough enforcement measures. And this is something that the European Commission is looking at right now. There is a project, it's called the Atlas Enforcement Project. And I had the opportunity to be the rapporteur for Cyprus. And it's going to be a very large-scale online system in which all the investors, they have the opportunity to see in each country of Europe how I can enforce an award or a decision I have in order to collect my claim. So this is why I'm always saying that the enforcement system is essential for a state, for a jurisdiction, for a legal order that needs to be investment friendly. Because at the end of the day, the investors, they do want to recollect. And the arbitration, usually, or via courts, we're going to be at that stage eventually. So we need to reform that. And I think it's one of the goals of the Minister of Justice right now in Cyprus.
Okay. So, George, you are a co-director of training for the European branch of the Charter Institute of Arbitrators, and I know that you are planning to do some training sessions for Cypriot lawyers. So, I want to discuss this, but before we go into the details, let us give us a general description or an idea about the Charter Institute of Arbitrators, what it is, what is its role, how it works, and etc.
Well, thank you. That's really something I very much wanted to discuss. So, there's lots of different ways in order to get trained as an arbitrator, and there's arbitration training out there. But and oftentimes this can be from universities or some of the institutions, like, for example, the ICC conducts some training courses. Delos is another institution which I think does some training as well. I would say, in my view, and I think the view shared by many, the premier institution for arbitration training is the Chartered Institute of Arbitrators. Now, the Chartered Institute of Arbitrators started in 1915, is when it was founded. And it was founded, I think it's always interesting to look, you're going to think I'm a history buff, but I really do think it's important to look at the history of these institutions. So it was founded by someone named H.C. Emery, who was a solicitor, but it was also founded by someone named F.M. Burr, who was an architect, I.W. Bullen, who was an accountant, A. Powell's, profession unknown, and A. Stevens was a solicitor. So actually, only two were solicitors.
Okay.
And the other three were not solicitors, which actually goes to illustrate the roots of arbitration in the UK, which is that it's not for lawyers. It's meant to be, a dispute resolution by experts in that same industry. So architects are judging architects.
Yeah.
And so because the roots of this were partly legal but also partly industrial, there was thought to form an organization, and the object was, and I'll quote, to raise the status of arbitration to the dignity of a distinct and recognized position as one of the learned professions.
Okay.
So the idea was to make sure that there's a certain high level of consistency among arbitrators in order to protect that arbitration as a dispute resolution mechanism. So if you don't have high and equal minimal standards of arbitrators, it was viewed that this would be bad for arbitration generally. So that was the founding purpose of the Chartered Institute of Arbitrators. And of course, therefore, as one of its central goals now for well over 100 years has been the education and training of practitioners who in arbitration, be they lawyers or not lawyers. And so that's really why I would say it's the umbrella organization internationally for arbitration training. And it has lots of different types of arbitration, not just international arbitration. It does, for example, mediation training, which Anna will know about. They also do construction arbitration, English domestic arbitration. So there's lots of different training out there. I mostly conduct the international arbitration on behalf of the Chartered Institute of Arbitrators. And the good thing about that training is it also then gets you recognized. There are certain statuses of recognition. So if you successfully complete that training, then you have certain levels of membership in the Chartered Institute of Arbitrators, which shows the world that you know something about international arbitration, and that knowledge and training has been recognized by the premier umbrella organization for international arbitration.
Can someone who is not a lawyer become an arbitrator?
Absolutely, absolutely. In fact, I think in England, I would say, roughly speaking, it's only about half. It depends on the industry, but if in the maritime industry, it's certainly only half of the arbitrators are lawyers, and the other half are other professions. Now, that's in England, okay? And certainly internationally, when we're talking about international arbitration, in most of the well-known, what we call seats of arbitration, so that there's no requirement that the arbitrator be a lawyer. But that can vary from jurisdiction to jurisdiction, and I'd be curious to hear what the position is in Cyprus.
What is the position, Anna, in Cyprus?
Well, in Cyprus, when it comes to national requirements, there is no restriction regarding the degree one has. Of course, civil engineers, lawyers, other individuals, other professionals, they also can be trained and become arbitrators. I would highlight that yes, I do think that training is important, is essential, not just to have the certification, but also to get the substantial knowledge in order to get those skills you need to have in order to conduct in an effective way and in a good way, let's say, an arbitration. So one should also, I agree with Yorgos, one should check the national requirements in every country, because sometimes in certain jurisdictions, like in certain states of the US, like California or Illinois, you need to have certain experience in the bar to be a member of the bar for certain years in order to qualify as an arbitrator. But in other states like Cyprus or Greece, there is no requirement not to be a jurist, not to be a lawyer. You have to be a professional. Actually, in Cyprus and in Greece, there is no certain requirement of having a training too. But I think that the training is important for the practice, for the essence of arbitration, not for the qualification of the certification as such. So yes, it is. I've been trained in all my life. Actually, I still do. So training is for the essence in this.
Yes, I guess I find it very strange personally for someone to be an arbitrator and not be a lawyer.
It's not really, but the question of what qualifications are required for a case vary quite significantly. In Cyprus, most of the cases we have are construction disputes, and worldwide, about 75% of disputes that go to arbitration are construction disputes. If we let's take two extreme examples. So if we have an example of the building of a house and a dispute between the contractor and the owner of the house for the valuation of extra work. That's of course something that does not really require legal knowledge. It's something that can be done by an engineer, and it's probably better done by an engineer or a content surveyor. In the same way as other issues requiring expertise may be better decided by a person who possesses that expertise. But if you take a purely, let's say, international commercial dispute, which raises difficult issues of private international law, issues of fraud, complex issues of contract law.
Well, this happens in live performances. Previously, we had a problem with the sound with Agis. Now we have.
If I may, Christophos, I would like to add that the discussion we have now, it's not the same in mediation. In mediation, there is a certain law that requires certain qualification and certain training. So
in Cyprus, you mean, right? Yes,
and in other countries too. So the legislator decided not to, organize the arbitration training or requires, but it's not the fact in mediation. Just for the people to know if they are interested.
Okay, I'll just say the one final thing is that again, it's all about party autonomy or the party's ability to choose. So really, everything depends on the arbitration clause. So if the arbitration clause says that the tribunal must consist of lawyers, then the tribunal must consist of lawyers. If the arbitration clause is silent, then it's really the parties are free to choose who they believe will be the best person to resolve that dispute, depending on what their qualifications or the right mix of people, which might include an architect, an engineer, and a lawyer. And then again, you're getting the best of all worlds that way. And again, another reason why people are choosing arbitration and not going to court, because if you go to court, you don't have any choice over who's going to be deciding that decision and what sort of background or knowledge that judge has.
And as you have seen, I'm allergic to dust. So if you have a dispute in Sahara, then we're probably not qualified to be the arbiter.
That's true, yes. I'm allergic too. I guess and it has been very difficult for me this last couple of days. George, what is the path to membership in the Charter Institute of Arbitrators? I mean, are there stages?
Sure, there's stages. So there's what they call an associate member, member, fellow, and chartered arbitrator. Associate member is, I think most people, if they have an introduction course and they have some basic interest in arbitration, they could become an associate member. Member requires the completion of what we call Module 1, which is the first of 3 courses with respect to international arbitration, if you follow the classic, what we call pathways training program. And that first module 1 course is about the practice and procedure of international arbitration. And that's usually a course which can be taken over a period of 3 to 4 months. It consists of 2 or 3 tutorials and a review session, lots of books to read. But again, it's not too onerous. And then there's an exam which is done, a centralized assessment now, which are all done online. And if you complete that, then you can qualify as a member. And then the step after that is then fellow. And if you can see after my name, it says FCARB, and that's Fellow of the Chartered Institute of Arbitrators. And that is achieved after you complete Module 2, which is the Law of Obligations. It's comparing civil law and common law. And Module 3, which is award writing. And Module 3 is really teaching you about how to write an arbitration award. So whereas Module 1 is for someone who is interested in arbitration, maybe as a practitioner, maybe as an advocate in arbitration, Module 3 is really designed for the person who wants to become an arbitrator and wants to know, how do I draft an award which will be enforceable around the world? Really, that's essentially the main training which that provides to the standard, to international standard.
And there are written exams for all 3 modules?
Yes. Okay. There's written exams for all 3 modules. And the last module is basically you're drafting an award. And then that award then is assessed by experienced arbitrators along certain objective standards to see if you've understood and you've met the criteria.
And Module 1 is, like you said, is like the entrance course, okay, to qualify to become an associate?
No, the introduction course. Course is not actually even required necessarily for you to become an associate, but it's a good standard to make sure that you understand at least the basics of arbitration. The next step is Module 1 to become a member of the Chartered Institute of Arbitrators.
And is this taught online now with COVID and everything?
Absolutely. So now virtually all of the training that I'm aware of now by the Chartered Institute of Arbitrators is, if not completely online, at least has an online element and possibility. So there might be a hybrid of some people in a room together, but the Chartered Institute of Arbitrators has invested in a state-of-the-art training program software. It's not Zoom. It's something else. And that's what's used to conduct the courses online. And I have to say, I mean, having done both, and I think probably a lot of people would agree with me, I actually prefer the online training that I did to the live training. I think it's a lot more convenient. It takes a lot less of a time commitment. Yes, you lose a bit of the networking, but that you might have in a live room, but it's a great savings of time, though. A great savings of time. So I really would strongly recommend the online training. Something you can do from your own home and with a minimal time commitment.
Yeah, I guess. How difficult will it be for a Cypriot lawyer to do Module 1? I mean, for the average lawyer that you know.
It's not difficult in the sense that it doesn't require that the candidate has anything more than knowledge of basic principles of law. So anyone can do it. And I think it's a very good course in the sense that it is designed to introduce and to push into some length into the knowledge that is required for someone to get involved in this practice. So anyone can do it, but I mean, from the course is not an end in itself. I mean, requires continuous effort in order to be able to cope with this type of cases.
Mm-hmm. Mm-hmm. Anna, from your experience, is this something that would be attractive to Cypriot lawyers, you think, or because there is this element of written exam, is something that is like a discouragement?
I would say it's not something that the Cypriot lawyers, or not lawyers, I mean professionals that would like to attend the course, it's something they can do actually. As George says, it's from your house, from your office, so you don't need to commute. It's online. The written exams are designed to to be able to respond to them after the training. So it's not something that one should be afraid of. And always, as I say to my students too, the exams, it's a very nice opportunity for you too to see your level. And those exams are not designed for people to fail. They are designed in a way that you can see actually that the training was effective and that you have those skills and the basic knowledge you need to have in order to go further. So I would recommend it actually because it combines substantial knowledge and procedural knowledge of arbitration. So this is important for the arbitrators to have knowledge of the substantial law and the law of the process, because arbitration has a lot to do with the process. That's why even professionals that they are not lawyers should have a minimum level of knowledge of law, at least the arbitration law. I mean, so yes, and also it's an international thing. Also, not only from Cyprus, maybe from other jurisdictions near Cyprus. I mean, it's online, so it could be attractive from neighbors too.
And you don't need to take the exam. There's no requirement that you take the exam. You can take the course, and then if you want to take the exam, you can. The exam is only to get recognized by CR about your knowledge, but you can certainly take the course and not take the exam. And I think the other one is to emphasize what Anna said is really, this is not it's not so much theoretical as it is. I think the real benefit is that arbitration is very much practical. It's how do you get from A to B in the most efficient way? What are some of the troubles you might run into? And this is why the lecturers who are teaching this are experienced practitioners who really are there. I mean, anybody can read the book about arbitration, understand the theory. But what you really want to understand from these courses is what happens in real life. And what are the practical situations I might encounter? And what's the best way to resolve those?
Yeah. George, from your experience, is the possession of this qualification offers professional opportunities to a lawyer? I mean, the opportunity to enter into a new market, to offer services away from the conventional court system?
I think it depends largely on the jurisdiction where you are. So I think in some jurisdictions, ironically, in countries like, for example, in London, I think that it's good to have the arbitration training and to have the recognition by CR. But of course, there's many, many very well-known practitioners of arbitration who are not qualified under the Chartered Institute of Arbitrators. They have no specific training in arbitration. And they're very well-known and effective arbitrators. But I think when you go outside of these large and popular international arbitration centers, then I think it has more value to have your experience recognized and your knowledge recognized by a neutral international body. And I can say myself, when you're talking about opening careers, if I'm looking to appoint an arbitrator, and let's say, for example, it's a construction dispute, and there's one very experienced engineer that I'm considered who is recommended, who does not have CRB training, and another one does. Of course, I'm going to choose the engineer with the CRB training, because I might be concerned that even though he might be an excellent engineer, he might make really just a mistake in the procedure, which then might render the whole award unenforceable. simply because they didn't have that basic training.
Yeah. One thing I did not ask is about the cost, George. What is the cost, approximate cost of doing this module 1, for example?
It's approximately a little bit over £1,000 if you do it from London. I think that's the latest prices came out about that.
Okay, which is it's not prohibitive. It's not something that is. Yeah.
Not at all, and I think those prices have actually come down because the costs have come down as a result of the online training.
Okay, so could you tell us a little bit about the planning this course for Cypriots? So, is it final or is it
the European branch conducts quite a lot of training throughout the year and out of various cities in Europe, and that's what we will continue to do. And we. And anybody can sign up to those courses from wherever they are in the world. So right now we're planning to do a Module 1 course which has a focus on Southeastern Europe, which it will look at the realities of Greece, look at the realities of Cyprus, but again, it's open to anyone to sign up for that course as and when it gets started. But that's really going to be the aim. That's the beauty of these regional training, is that it actually then brings it back to the reality of that jurisdiction. I'm just now finishing a Module 1 in Moscow, which we do every year, and that is also done, with the context of what's the Russian reality of international arbitration. So, although the training is the same everywhere, so it's a standardized Module 1 training all over the world. If we have some trainings based on regions, then sometimes it can help people share their own experiences in that region. And oftentimes people can learn from each other within the course. As I said, it's practical. So people have different experiences. And if people are from the same region and they can share those experiences, then that's really to the benefit of everyone.
Christina asked here about the costs, and I have already asked you about this, about Module 1, and she also asks about the qualification, whether it has to be renewed every few years. So once you pass Module 1, that's it?
That's it. It doesn't need to be renewed. Membership to the Chartered Institute of Arbitrators is renewed every year, but the qualification does not need to be renewed.
Maybe
one other thing I would say is that in addition, when you join the Chartered Institute of Arbitrators as a member, you're also signing up to a code of conduct, which is a very important element. So it also means that if, for example, there's been an arbitrator who is a member of the Chartered Institute of Arbitrators who is accepting a bribe, something like that, then there will be consequences. An application could be made. That person would certainly be removed from the Chartered Institute of Arbitrators, and that's basically the end of that person's career. So that is a good incentive to maintain certain ethical standards, and that's one of the statements I think that you need to complete when you renew your membership at CIARB, is whether or not you've been convicted of a felony or something else which would compromise the professional integrity of your role as an arbitrator.
Okay.
Just to clarify there that you don't need to repeat Module 1. I mean, once you repeat it, that's it. But if you want to use the title of FCIARB or MCIARB or whatever you are,
you need to be a member.
It's required that you renew your annual subscription every year. Yes, there is a cost to it, and it increases as you go up the route to fellowship.
Okay, Anna, what would be the skills that someone has to possess to become an arbitrator or be involved in this? I mean, can you say, can we paint a profile of the professional or the lawyer that would be good or interested in this?
I would say that an arbitrator should be a professional and always act as a professional in his field, and also to be a person who respects the rules. because we need to play by the rules, and in order to be effective. Of course, an arbitrator should always be a decent person, a neutral person when it comes to the dispute. It's very important for us, for our for being able to parties to choose us and to be present in the market, to act in a professional way, and to respect code of conducts and all other rules, to respect the clause in each arbitration, because that's the way we actually build our profile. It's a free market after all, so we need to prove in every case our value and our professionalism.
Yeah.
So it's not a market for people who want to have one or two jobs and go. It's not that the way that the game goes.
It's ongoing.
So and also the matter of expertise. I don't believe that one can be a general practitioner and knows everything and be effective in every field. So expertise is important. George said, for example, maritime arbitration, or insurance arbitration, or energy arbitration, or commercial arbitration. So one should, focus in certain fields or certain sectors in order to be better, in order to be expert at some point. In
Okay.
this.
And George, I guess that the training takes place in English, right? I mean, it's in the English language, I suppose.
That's right. The training is in English. There have been trainings in other languages around the world, but I think this training in the European branch is done in English, and my own experience and preference is that it is carried out in English, because that's generally accepted to be the language of international arbitration. Again, it's not exclusive, but that just tends to be the language which is used.
Do you have a date for the seminars, for the training?
Not yet. No, I mean we're working on the dates now. But what I would say is that anyone who is interested in training can go to the website of the Chartered Institute of Arbitrators, and there's a list of courses that are of Module 1 which are planning to take place. So they don't necessarily need to, wait for a course, this course that we're thinking about now for Southeastern Europe. There is training already out there available by the Chartered Institute of Arbitrators, and I would encourage them to go and look and find that. And then if this course, or not if, but when this course takes place, then that course will be listed among the courses that are up there for Module 1.
So do you need to have a minimum number of participants or not to schedule the training?
Not really, but I mean, I wouldn't want to conduct it if it was sort of less than 5 people. Really, more the problem is the maximum, and that's really, we want to keep the numbers to a level whereby you have a good one-to-one training and discussion. So I really wouldn't want it to be more than 15, 16 people. I think that would really be the maximum.
I was discussing this with Hannah, and personally I think that if this gets published and it's advertised in a way, there will be many interested colleagues, at least from Cyprus, and certainly more than 10 or 15, I would say. Anna, is there a way to promote this prior to being officially announced or not?
Actually, I would say that if anyone is interested, could reach me or Agis, and we are in the process of organizing this and planning actual dates and the list and etc. And
So,
permit me to say additionally that in some arbitrations I was selected because I am a member of the Chartered Institute of Arbitrators, and not because I'm an academic or an experienced arbitrator, I would say, or I mean additionally to that.
Yes.
So yes, if I'm not interested, yes, please contact us, reach us, Agis, me. We are planning it. Yes.
Yes. I guess closing, I would like to hear your opinion on this professional qualification advantage. Is it something that would be good for a Cypriot lawyer to have on his CV? Will attract any new business, you think?
So I think that there will be an increase of arbitration work in the next few years. Mm-hmm. So there is a potential there for a Cypriot lawyer to increase his workload or to specialize in this field if he or she wants to. Mm-hmm. But if we can put the interested persons in two main categories. There are people who are interested in learning about arbitration and may take the course, but they never actually, they may not pursue a career in it, which is absolutely fine. And then there are people who want to do this course because they really want to get deep into arbitration. For the latter category, the course is just a start. Getting into this field requires a lot of knowledge. It is very multidisciplinary and requires knowledge of good knowledge of procedure, evidence, international law, commercial law. It's a continuous effort to be educated on these issues. And it's also very important for that person to be present in what is going on in the world of arbitration. And I wanted to mention this, how I met with the other two on this panel.
Yes.
I've met George more than 10 years ago when we were being trained together in Moscow for an ICC arbitration course. That was a course, it lasted for 2 years, so we had the opportunity to meet several times. Since then, we've done several things together, and I'm very proud and honored to have George as a friend. I met Anna, I think, several years ago, maybe 6-7 years ago, at a conference on arbitration in Cyprus. Since then, we've met several times in other similar events. I ended up being educated by Anna. Now we are planning. After that, George actually did a course that both me and Anna took. So we were his trainees, and now we are co-trainers with George in another course. Okay. So what this shows is that it's not enough just to take a course or to attend an event. If you want to get into this area of practice, then you need to attend these events, you need to build up your relationships, and it's a continuous effort that takes a lifetime. It's a commitment.
Yes.
And it's a community. And it's a community all around the world, and which is quite a close-knit and friendly and wonderful community. And you can speak with lawyers in Brazil or China or anywhere who are involved in international arbitration, and we all speak the same language and share the same standards. And I think that, if for no other reason, to being a part of that community, I think is tremendous.
Yes, you are right, George. In the case of Cyprus, my personal opinion is that all lawyers should pursue this, and they should at least try to find out more about it, and if possible, do the training and be involved in these professional bodies, especially because of the dead end of the Cyprus legal system. I mean, our system here has huge problems, tremendous delays. Agis mentioned before 8 years to get a first instance judgment, 5-6 years for an appeal to be heard. So, I mean, you start now and you finish when you get a pension. So we need to find other ways to find business and also offer alternative solutions to our clients. And Anna and Agis, do you know what is going on with the domestic arbitration law? There was some discussion to update it, to change it. Do you have any ideas?
Agis knows more. We are both in the arbitration and mediation committee of the bar, but Agis knows more, I believe.
If you could say a couple of words, Agis, and we close with this.
Yes, well, there is okay. there has been a discussion about amending the law for several years now, but I think that the effort that's taking place now is led by our colleague Stavros Pavlou.
Stavros. I had a podcast with him in the past about this.
Yes, I think he was an interviewee a few months ago. Anyway, what seems to be the position of most practitioners is that we should allow opting in to the international commercial arbitration law, so that all arbitrations, be they domestic or international, can be tried under that law. So that's a very, very important issue. Then there is also a discussion about changing Law 121, which is the procedural law for enforcing judgments, and it is quite problematic. Well, it is problematic because of the way it was interpreted by our case law, but that's a huge discussion anyway. So there are some issues about jurisdiction which have to be resolved with that law. So I think that we will have these changes fairly soon, and I think that this, combined with the introduction of the commercial court, will bring a huge positive impact on international practice in Cyprus.
Okay, so I have also posted the links to your CVs here. So if any Cypriot colleague or professional is interested about this training, they should contact Anna or Agis or even myself, and I can guide you through. So I think we have discussed and covered most of the areas. George, I would like to thank you very much for your contribution. It's been really an honor to have you here and get your input and ideas. So if you would like to say a final word, and then Anna and Agis, and we close.
Sure. Well, I just wanted to thank you again, Christopher. It's not so often that we really have such an interesting forum to be able to discuss, in such an atmosphere, really practical things that we can be doing to improve ourselves as professionals. And I thank you very much. And I especially wanted to give a warm thanks to Agis and Anna, who are really at the forefront, pioneers of international arbitration in Cyprus, and it's really an honor for me to be with them, and I really encourage them in their work. They're doing tremendous things. Thank you.
Well, it's my pleasure. It was my honor. I always love to be among these wonderful gentlemen, and thank you, Christopher, again for having us. I would also like to add that the course is suitable, and I think it's going to be very useful also for lawyers who want to represent clients in arbitration, not only for those who want to act as arbitrators, because they're going to have the insight of arbitration. So from several aspects, I think it's going to be useful. And thank you again for having us.
Agi?
Thank you, Christopher. You've been a wonderful host. Thank you to my friends, Yorgos and Anna, for being in this panel with me. I don't really have much to add. I just want to stress that arbitration is a quite fascinating area of practice, but it does require a significant effort. So it is for people who are committed to do it. And if anybody from the audience has any questions or wants to listen to our opinion about any of the matters we've discussed, or where to train, or which course to do, we are all at their disposal. Thank you very much.
Okay, so thank you too. I hope that we are going to have this training, George, Anna, and Agis, very soon, and you will be our co-trainers, and I will be a student. Hoping to find out, or
that's a reason for many people to attend, because you're gonna be one of the candidates.
You think so? Okay. Thank you so much. It's really been an honor. I'm enjoying a lot this professional type of podcasts because I think we give substance and value to our colleagues. And I mean, I feel very proud about this every time that we do this kind of discussions. Thank you very much. Have a nice week ahead. Tomorrow we are going to have another political type of podcast. So we are discussing in Georgia about the Cyprus problem tomorrow with two very esteemed personalities here in Cyprus, but I don't need to bother you with this.
Well, I'll be sure to tune in.
Have a nice evening.
Thank you.
Dear friends, thank you for tuning in, and we'll see you tomorrow at 7 o'clock. Bye-bye and good night.